Hello everyone and welcome to today's Mondac webinar in association with Bonar Law, whose experts will be providing actionable advice for in-house lawyers framed in the context of trending antitrust and merger related issues. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Stephen Cernak is a respected leader in the international antitrust and competition law community. He is the chair-elect of the antitrust section of the American Bar Association and will become chair in 2024. Prior to Bonar Law, Steve served as in-house antitrust counsel at General Motors for 20 years, responsible for mergers, antitrust litigation, and global antitrust compliance. Steve has experience tackling the toughest antitrust issues and assists clients on a wide array of competition and consumer protection matters, including compliance, joint efforts with rivals, pricing strategies and programs, and merger reviews and filings. Pat Pasquarella has successfully represented clients in the most important Supreme Court antitrust victories in the past 20 years, including Bell Atlantic versus Twombly and Pacific Bell versus Linkline. Prior to Bonar Law, Pat was Chief Antitrust Counsel at AT&T, served with the US Department of Justice's Antitrust Division, and chaired the Antitrust and Competition Law Group at a major law firm. Pat was recently retained by the California Attorney General to serve as trial counsel for the government in the prosecution of a high-profile price-fixing case. And completing our panel is Molly Donovan. Molly is an antitrust litigator and former partner at an AmLaw 50 firm with over 15 years of experience representing clients in antitrust disputes. Molly has defended clients in connection with worldwide cartel investigations and has represented companies and individuals in criminal proceedings by the Department of Justice's Antitrust Division. Molly defends clients in private civil actions alleging price fixing, no-poach agreements, bid rigging, group boycotts, hub and spoke conspiracies, market allocation, and other competition-related claims in multi-district class actions and other complex litigations. Before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of a toolbar on the right-hand side of your page. We do encourage you to send in your questions. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thanks, Dan. You all have done an amazing job getting us here today and set to go. Hi, everyone. Thank you for joining us or listening in. I'm Molly. Today, I have the unique opportunity to talk to Steve, who, as you heard, served as antitrust counsel at GM, and to Pat, who served as antitrust counsel at AT&T, about how they would approach some of today's greatest challenges in antitrust. I think this is pretty epic, being able to pick the brains of two former in-house lawyers at two of the world's largest companies. And so I've come up with questions that I hope will be of significant interest and also useful as a practical matter to the audience to make the most of this opportunity. So Steve and Pat, we're going to proceed Q&A style. I'm going to try to address each question to one of you to maintain some order, but both of you are invited to comment as you'd like. Steve, I'm going to start with you. My first question is a general one about antitrust compliance programs. If you had to choose, what is the one key to an effective antitrust compliance program and why?
Well, thanks, Molly, and good luck trying to keep order between us. One element that I think is most important is getting top executive buy-in. That means, if in best case scenario, you've got the CEO right next to you as you are on the screen giving a virtual presentation or on the stage giving it an in-person presentation. Or her pictures in the brochure or on the intranet, a video presentation. But you want to make sure that that the CEO and the C-suite have bought into the importance of antitrust compliance, and that they've communicated that officially to everybody else in the organization, but also unofficially. You do not want to have any sort of whisper campaign that, this is just flavor of the month. This is just something that, the legal staff or the law department made us do. But instead, it's something that they are really buying into. I think that's really best practice. I think that's been best practice for years. And if you don't believe me, at least go, read some of the speeches in the last 10 years from the Department of Justice Antitrust Division on what makes a good antitrust compliance program good to stay out of their crosshairs, but if you get into them, good to at least get some consideration for leniency. A culture of compliance is what DOJ calls it, but I think it's just basically making sure that everybody buys in and everybody throughout the organization understands that the people at the top buy in.
Pat, did you want to add something?
I don't want to be out of order, but I'm going to, at the risk of that, that's obviously the most important thing. People listen to the person that signs their paycheck. I'm sorry, that's the reality of the world. If there was a second item, though, I'd say it's relevance, right? You have to make the training granularly relevant, right? The factual scenarios, the hypos, they have to be very specific. Who do you want to not do what, and where are they going to encounter it, right? You have to make it very easy for the employees to identify the risk scenario, right? That has other benefits as well, right? It shows them you're familiar with what they do. Employees like that. It makes you feel like you're part of the team, right? This Pasquarella gets it. He understands what we're out there doing. And they're going to be more likely to follow your advice, right? And for the cynical out there, it lets them know you're aware of the opportunities for mischief, right? Just in case they were thinking they were going to get away with something. So yes, officer buy-in, head and shoulders above all the others, but a very specific, very relevant program is absolutely necessary.
I think that's a good segue to my next question. And Pat, I'll address this one to you first. When a new topic starts trending, how do you know when it's necessary to train or retrain the relevant people? And I'll give you an example if it helps you. There's been a lot of buzz in the past couple of years about the potential resurgence of Robinson-Patman Act claims. In reaction to that buzz, should in-house antitrust counsel be training salespeople about price discrimination?
Yeah, kind of love the Robinson-Patman Act, right? I think it's the only antitrust law that makes no economic sense, right? Which is, I guess, why it's so perfect for the Federal Trade Commission. We've seen a number of creative or trending theories of liability. Trending is sort of a polite word for them. I don't think this question is necessarily unique to in-house, I think, but it's a good question, right? You've got limited runway space. You can only train so many people about so much, right? So you're going to include things that are likely to cause the most damage if you get sued or investigated, right? So for the trending theories, I'd be thinking about, who uses these theories, right? They're looking for, it's people that are looking for a way to sue you, right? Or to open some investigation that they could tout publicly or to the voters, right? So, the first question you've got to have as you're thinking about it is, is your company, do you have enemies like that, right? Is your company that sort of target? At AT&T, we toyed with changing our logo to a target, but someone was already using it. But, a good clue that you might want to train your folks is if in the FTC press release announcing the revived theory, they mention your industry, okay? That might be a clue to start training your folks. The other questions are, would your industry be potentially susceptible to such a claim? The cost to train versus the cost of getting out of the investigation. But let me leave you with a different thought, right? Remember what we said, these are people that are looking for an excuse to sue you, okay? Or to investigate you. So maybe training isn't really the answer, right? And when you're in-house, you really have got to be thinking outside the box because, that's the mantra, right? Rather than train, is there something you can do that broadcasts that you're ready for, okay? Basically, is there something you can do that's akin to putting the ADT alarm sign in your front yard that tells the burglar, you should go to my neighbor's house, okay? Maybe you strip away the appearance of a potential violation, you announce some policy. It's going to be unique for each thing, but for the trending theories of liability, maybe training isn't necessarily the answer.
Makes sense.
I'm gonna jump in and take you up on your offer of Robinson Patman, because I don't get too many opportunities to talk Robinson Patman, so I want to take advantage of everyone that I can get. You know, it's been 30 years. 30 years ago, we used to make fun of the in-house guys who were, and there were guys, all guys at the time, who were, you know, we need to pay attention to Robinson Patman. You know, this is important. Oh, no, it's going to go away. You know, nobody worries about that anymore. And I have come around to the idea that it's never going to go away, and it looks like it's coming back. But to get back to your original question, Molly, does that mean that you end up training everybody on it? No, all of Pat's comments are right, that you need to train the right people at the right time, and, you know, for the right reasons. But here, I don't know that I would, that so much it's training as making sure that you are getting to the right people at the right time, and, you know, perhaps telling them that, you know, you need to pay at least a little more attention to this area of the law than you did maybe 5 years ago, or certainly 10 years ago. You know, so for Robinson Patman, yeah, 30 years ago, General Motors had a lot of written forms before you could lower a price to a particular retailer. I'm talking about replacement parts, not cars. You know, you needed to fill out a form, and it was a several page form. We changed that when I came in, so that, you know, instead of there being forms, you know, I went to the right meeting where these kinds of pricing decisions were made, and we kept, you know, notes as to why the price reduction was made. So if we needed to, we could get into the meeting competition defense. But we ended up doing all of the same sort of things much more efficiently. If you are, you know, in the room where it happens, it's much easier to provide that kind of advice, and, you know, to make sure that, you know, everybody understands that you're a team player. So I'm going to, for a change, agree with Pat here, that, you know, it's not just the training, it's making sure that you're in the right place at the right time.
Steve, my next question I think is related, but a little bit different. Everyone is talking about antitrust relating to generative AI. For example, a few companies have control of massive amounts of data, and or competitors are able to use AI to at least tacitly collude. So as we all know, that the tech here and the law is evolving very quickly. Do in-house lawyers need to update their compliance programs in real time to keep up with changes in this or in similar fast-moving situations?
I don't think the updates need to be real time. I don't think you need to update a program, you know, a presentation, something that's on the company intranet, for every change in AI. That's something that, you know, nobody can keep up with that, and I don't think you need to keep up with that. If your presentation, your standard antitrust compliance presentation, was written 15 years ago, well then, yeah, you do need to update it, but I would update it to include data as something that's important, not the latest in whatever, you know, AI evolution has gone on lately. To help people understand, help the client understand that it's not just products, it's not just services, but that the you know, the plaintiff's lawyers and the investigators think that, you know, data's the new oil, data's the new gold, or whatever the analogy is. And we don't need to debate whether those analogies are correct or not. But that those are areas that were not as important a few years ago. They are important now. Then, you know, as this, you know, something comes up that you read in the Wall Street Journal or the New York Times, so you're paying attention to what your business people are paying attention to. You're there to discuss it with them. You're there to answer their questions, or even better, more proactively, you know, let them know what they should be thinking about, and how what they heard from you last week or last month applies to this latest change. But I don't think you end up needing to change the presentation that often. just because, something's changed in the scientific world.
My 2 cents?
Sure. Let's have it.
Let's go back to the Robinson-Patman Act. So I have a brother who's 2 years younger than me, and when we were kids, every new toy we got, the first thing we did was try to figure out a way to make a weapon out of it. Okay. I mean, some of you are old enough to have made your own Tinker Toy bow and arrow, or shot an Estes rocket engine at somebody.
You're showing your age again.
And I asked Molly not to do that to me, and here I'm doing. To the extent your client's using the new technology, you have to be aware of how it can be misused, okay? Because your clients are going to figure out a way to use it to gain a competitive advantage, right? That's their job, all right? Their job isn't compliance with the antitrust laws. They need to comply with the antitrust laws. Their job is to gain a competitive advantage over their rivals, right? And if they've got a new toy, a new piece of technology, a new piece of software that gives them that competitive advantage, they're not going to say, well, gosh, I wonder if Pat's going to be okay with this, right? So you as the lawyer have to be aware of the technology. You have to be knowledgeable enough about it to understand how it could be misused. And, plus I think, we're a long way off from how did it being a viable defense. So yeah, fortunately or unfortunately, get with it.
Okay. All right. So Pat, now all of your relevant people have had good compliance training on the topics relevant to them, and your business people are now out there making decisions and doing stuff, sometimes in borderline situations or situations not specifically covered by your compliance program. Ideally, these are situations you'd want to know about before the business people act. How do you get them to ask before acting? Sorry.
All right, I'll give you this sort of outward bound answer to that, right? I can't answer that in every scenario, but I mean, I think these are sort of the core underpinnings that will get your client to do that, right? Obviously, the officer advocacy that Steve talked about goes a long way in this regard as well, right? You, the attorney, you have to be viewed as a team player, right? Your clients get paid to succeed, and you cannot be viewed as a hindrance or a roadblock or even a delay in that process, all right? And you have to consciously work on fostering that view of yourself. I mean, there's a little bit of a marketing job involved with being in-house. So it's important that your client view you as a team player. You have to consciously work on that, right? I always add in and play to a little bit people's instinct for self-preservation, and I'm going to give you a free one here, okay? I stumbled on this years ago by accident because I said it at a meeting, and it turned out to be one of the most effective things I've ever said in a compliance program. What I said was, someday you're going to get a call to go up to your general counsel's office, and when you get there, your boss's boss is going to be there with the general counsel. When you're there, you're going to be asked one question, and that question, your answer to that question, is going to determine how the whole rest of your day is going to go. And that question is going to be, did you talk to Pat before you did this? Okay. I was just trying to be my usual amusing self at a compliance. I heard that back 100 times, right? And so basically what I did was I made it real for them, right? Sometimes the risk is so high you have to impose some sort of legal gate. Steve talked about using the forms for the Robinson-Patman Act. Those instances do arise. I would tell you, though, that they're very, and I'm sure you learned this with the Robinson-Patman forms, they're very resource intensive, okay? And they pose a very great risk of you becoming the bottleneck. So think real long and hard before you impose some actual toll gate, as opposed to maybe taking Steve's path, which is, getting to the source. Anyway, I think that's about the best you can do.
Yeah. So on that one, Molly, and I know we're sort of segueing into even the next question, but I mean, I do think you want to make sure that you're seen as a team player. I do want to, you want to make sure that you are helping the client do his or her job. That's the whole point. So for instance, talking about, gathering competitive intelligence. One time when I was at General Motors, one of my clients wanted to work with this third-party consultant to, share information and with other competitors as well, and then this consultant would aggregate it and then share the aggregated form back. And I took a look at what was going to be shared and how it was going to be displayed back to the client, and said, yeah, I think this works. Maybe tweak it a little bit here or there. I found out, a couple days later that they'd gone to, my counterpart at another competitor whose name will not be mentioned, but they're based in Dearborn, Michigan, and understand that, he had said, no, you can't do that. And so I was asked to get on the phone with him and say, hey, why did you say no? I said yes, so long as you did it the right way. And his reaction was, because we know they're going to screw it up. We know that they're going to end up getting into trouble doing this. Yeah, they'll do it right the first time, but there's not going to be a lawyer there all the time to make sure they do it right going forward. And I said, well, what if I review these sorts of programs and this sort of information sharing, for the industry, along with our counterparts in Highland Park and Auburn Hills. And the answer is, if you want to do that, okay. So as a result, I was able to work with my own client, General Motors, but also other clients and the third-party consultant to do something that the client really wanted to do. I think that bought me a lot of credit, so that the next time I needed to, say no, or the next time that, did you ask Cernak? Did you ask Steve to play off of Pat's advice? They had been willing to come back to me because they knew that I would not say no automatically. I would try to find a way to get to yes.
Perfect transition. What if you do need to say no? How do you do that and still be viewed as a team player? And I have a scenario for this one. Your CEO wants the business people to be able to message each other via WhatsApp or Snapchat, where once read, the messages disappear. You've been asked to bless this, but you have reservations. What do you do?
Well, first, I just wanted noted for the record that Molly came up with this question well before the Department of Justice and the Federal Trade Commission sent out their notice last week that they're very, very interested in all this ephemeral messaging. So Molly's psychic.
My special lawyer psychic powers.
Yes, that's what we're trying to tap into. So here, I think you've got to make sure that you explain the risks to the upper management, that this kind of messaging, this kind of way of communicating is it's not that it's suspicious in any way, but in certain circumstances, like when there's a litigation hold, because you're involved in litigation, you could be involved in litigation, you're involved in an investigation. This kind of communication, could get us into trouble, or we might need to change around that communication system, once we have a litigation hold or something like that. But here, even despite last week's message from DOJ and FTC, where they said, when we ask for all communications, we mean this stuff too. Even despite that, I don't know that I would jump in front of this train and say that, to the CEO, you can't use WhatsApp, you can't use Slack or Teams or any of that. Just that if you're going to use it, we need to make sure that we can collect the information when we need to, but maybe not necessarily always. But when we need to collect it. So I know we're talking about when do you, how do you say no? But here I'm struggling because I'm trying to get to a yes, and I'm trying to get to a here are all the risks. It might be a big problem later on. But so long as everybody knows that, then maybe we let them go forward. But I'm interested in what my friend Mr. Pasquarella has to say about that.
Yeah, this is a pure marketing play, I think, right? I mean, what Steve explained was how you say no. But it's hard, right? And my advice is really contrary to what you learn in law school, contrary to what you see in big law, right? Which is be cool, be objective, don't take it personally, all right? When you're in-house, it's personal, okay? Especially if it's bad news, all right? You're telling a client they can't do something that they need to do to succeed, okay? To take care of their families, all right? It doesn't get any more personal than that, right? So let them know you see that, all right? I mean, whether it's pointing a finger at the Justice Department, those darn justice guys are, off on some frolic here, but we've got to deal with it. I mean, let them know that you feel their pain, right? You're gonna say no. If it's something that has to be, if you can't say no and you need to say no and you're in-house, you should probably look for another place to work. But you're gonna say no, and the client's not gonna like it. And you're going to build up some credits, as Steve said, by doing things like the story he told. I myself was handcuffed in the lobby of the headquarters building one day. That I rode that for 5 years.
You're still riding it.
That's a story for another seminar. But you don't be afraid, and actually make a point of letting the client know that you too think this is BS, but it's the BS you have to live with.
All right, sticking with bad news. Something bad has happened despite your very good compliance program. Let's say you discover through an internal audit that at an HR conference 6 months ago, your HR team discussed specific terms of hiring and comp with HR teams at other companies that compete with you for labor. How do you deal with, oops, we did that?
Is that me?
Yes, that is you, Pat. You're our bad news guy.
Yeah, I was detecting a trend. So let's ratchet that hypo up, all right? They agreed on specific wage levels, they implemented mechanisms to police cheating, and they've been engaged in it for the last 4 years. Okay. And we'll make it interesting by let's say, we're not reacting to an investigation or the filing of a lawsuit. In other words, the conduct's been undetected, all right? Now what do you do, right? And the short answer, right, is you have to fix it, but what do you actually do, all right? And I've got, yes, we cheated, and Molly told us the questions in advance. But I've got 5 things I wanted to tick off, right? That I think that there are things to keep in mind, and 5 is just an easy number for me to remember. And you've got to do these 5 things fast, all right? Especially if there's potential criminal exposure, all right? Thing number 1 comes from my favorite Mark Wahlberg line in the movie Shooter, which he stole from the Marine Corps, which is slow is smooth, smooth is fast, all right? The first thing you do is you take a breath, all right? And I know that's contrary to my other advice, but this is the one time you don't want to take it personally. All right, everyone around you is going to be looking for someone to blame, frantic about it, angry, upset. You're the calm, cool person who's going to steer the ship away from the iceberg, or at least you're going to get as many people off the boat into lifeboats as you can. That's going to serve you well in this investigation. It's going to serve you well, when people remember it in the future. All right, so that is not an unimportant step. Take a breath. But while you're taking a breath, unless you're an ex-AUSA, you want to immediately loop in your criminal law attorney, okay? If you don't have a good criminal law attorney on your contacts list, I'm talking to the in-house folks now, find one this afternoon, okay? A criminal lawyer is like a gun. When you need it, you better already have it, okay? You're not going to have time to go looking for it, all right? And I'll explain that a little more as we go into this, right? Now what you need to do is get ahead of everybody. You have got to get in there quickly and find out what happened, all right? You need to know what happened, who outside the company knows or has been affected by it. In other words, who might reveal this before you, right? And as you're doing that with your criminal law attorney sitting right next to you, be real clear about who you represent. Okay, I mean, this is a topic for another day, but in your ex-AUSA outside counsel can help you understand the upjohn requirements, the privilege issues. You know, these things all relate to the fact that the people you're talking to and the people you represent, i.e. the corporation, might not have identical interests, right? You've got to be able to get that information quickly and do it in a way that doesn't prejudice you or your company, right? Then you need to think like a political animal for a moment, right? This is step number 4. Who needs to be advised, right? Who needs to know, right? And when do they need to know? You know, is this person someone that needs to know immediately? Is it better to let them know after you've come up with a solution or after you at least understand the scope? And then step 5, these aren't really steps, these are just things to remember, I guess. Number 5 is before you go external, all right, be 100% certain you understand the scope of what you're about to report, all right? Yeah, I'm not saying I've been in a situation where something's been self-reported and we later learn that the potential fine exceeds the value of the company, all right? But be real sure that you know what you're reporting, okay? So you know, so my advice, take a deep breath, call your criminal lawyer, get the facts fast, advise anyone that is politically wise to advise, and be certain of what happened before you go outside. I don't know, that's a mouthful, but that's my advice, sticking with it.
I'm going to strongly agree with Pat on all of those, but I'm going to emphasize a couple of those points. First, congratulations, you, according to Molly's facts, you updated your antitrust compliance program sometime recently to emphasize labor issues, because that is a key area for the antitrust agencies these days. And you know, your HR people are, you know, unlike your salespeople, unlike the marketing folks, you know, might not have had antitrust compliance programs given to them for years and years and years. And I've found that the HR people might think that, you know, well, we can just go talk to our competitors, and you know, the competitors in the product world might be different than the competitors in the, you know, labor world, where you're all hiring the same kind of engineers, even though you're going off and making different products. So great, you did a good job at updating your compliance program. You talked to the HR folks, except yeah, they messed it up. So Pat says to take a deep breath. My version of that is to, you know, call a timeout, go outside and scream, "What were you thinking? You didn't listen to me. I told you not to do this." And then come on back in and do everything else that Pat already described.
All right, Steve, I think this next one is going to be your favorite because we're switching to mergers for a little bit. There's been a lot in the news about Illumina's recent decision to abandon a vertical acquisition of Grail, its former subsidiary. That was after an initial win against the FTC, but then ultimately a loss before the Fifth Circuit. It took 3 years from the deal being announced to the decision to divest. As in-house antitrust counsel, what is the lesson to learn from the Illumina story?
Well, I think the first lesson and the substantive antitrust lesson is that when we're talking mergers, we're not just talking horizontal issues anymore. You know, sometimes people come in and talk to me and say, "Hey, this merger should, you know, just slide right through the Hart-Scott-Rodino process because there's no current competition." Well, that's helpful now, but that's not the last question that you ask. Vertical issues or non-horizontal, non-vertical, let's call them conglomerate issues, are hot, sexy these days at the agencies. In fact, sometimes it seems to me like they're more interested in those issues than they are in you know, the old-fashioned horizontal issues. But so those, I think the big substantive lesson is you got to get beyond current competition, horizontal competition, and look at potential competition, vertical issues, and the like. But the second lesson, how do you avoid 3-year wait or a 3-year process? I don't know that you can avoid it, but I think the right way to think about it is you need to understand and educate your client that it might take several years in order to get it through. One way to figure that out is to ask a couple of basic questions right up front. First, ask your CEO or other important people, why are you doing this deal? I mean, what's your elevator pitch for explaining why this is a good a deal for the company to enter into? Is it because the target has been bothering us on price and this will take care of that issue? Or is it because we're going to round out our product lineup and we'll be able to better serve our customers? We need to have that honest conversation to understand what it is that's driving the deal. And then sort of related to that, we want to make sure that, what will the customers think when, they get told about the deal? Is their reaction going to be, OMG, this is terrible? Or is it going to be something, like, yeah, I used to have 9 different suppliers. After the merger, I'll have 8. Yeah, so I'd rather have 9, but I can live with 8. Or, yeah, there's some great technology that the target has, and the buyer is going, can make better use of that technology. What will the customer say? So I think what you get from Illumina Grail is, okay, first, it's just because it wasn't horizontal, didn't mean that it was going to be, walked through in the park from an antitrust perspective. But you also need to make sure that you're trying to get a better understanding of what your customers are thinking, how your customers will view this transaction, because the agencies are going to be calling them, certainly within the first 30 days of the HSR period.
All right, I'll expand it in terms of lessons from all the mergers we've seen. Just real quick, right? Two ideas, right? No longer any reliable criteria to determine if a deal will be challenged or how long it's going to take to clear. And we're pretty sure it's going to take longer than it did in the past and that it's going to involve litigation, all right? If you have never been in-house during a merger, you have no idea of the level of angst and damage that is caused internally by unanticipated delays, changes to the deal, uncertainty on its closing dates, what's the final deal going to look like. It is devastating, and it occurs on both sides, the acquirer and the target. Right. So the thing I would add to what Steve just said is to underscore something that he said. The best thing you can do for your clients, other than getting the deal ultimately approved, is prepare them ahead of time for what they're about to encounter, right? My lawyer warned me about this goes a long way in diminishing that angst and damage. And the damage is real. People leave, so the more you can do to sort of prepare both sides ahead of time for what they're about to encounter, the better off you'll be, 32 months into the clearance process.
All right, Pat, one more on mergers. What is pre-merger integration planning and why should you do
it? Yeah. Maybe you shouldn't. The idea of pre-merger integration planning is you can capture synergies faster after you're allowed to close by having planned with the other side. And it's a fairly elaborate process. It's fairly costly because you have got to make sure you don't do anything that ultimately adds to the delay of clearing the merger because you're talking about business and post-merger plans with the other side, right? But there is, in fact, a lot you can do ahead of time, okay? Sometimes it's worth it, sometimes it's not, all right? The one thing the thing that I would add, though, I mean, because everyone knows about pre-merger planning and then they all think about it and they all end up doing it, is the one thing that we didn't realize, and frankly, I think in a lot of, I think we're the guys that actually invented it, but we had a deal many years ago as we were starting to put Humpty Dumpty back together again. We were buying Pac Bell. This was mid-90s, right? It took over a year to clear. And during that period of time, people were just sitting around waiting, right? And it was not good, right? A lot of emotional carnage, right? The next big acquisition we had, we implemented something we called pre-merger planning, right? And it turned out that this was a huge purge valve for this angst. All right. I mean, obviously not the entire organization is involved in it, but there's a lot of trickle down from it. So pre-merger planning is useful, particularly in a synergy deal, to capture those synergies faster after you're allowed to close. But look real hard at that. You know, sometimes their cost isn't worth the benefit, right? But the added benefit, which is not insignificant, is it does serve as a real purge valve for the angst that derives from, you know, having to wait a year, 2 years, or more to see if you're still going to have a job and what that job's going to be.
Yeah, I again agree completely on that. To the extent that you can do that kind of planning, that again is helpful to the business. It's helpful to the business now, sort of a release valve, but also it's helpful to make the merger more successful if or when it goes through. And I think that's just another way of being a team player and helping the client do what it is that it thinks is in the best interest.
All right, my last few questions are general ones, but I think they're the hardest. So Pat, what are 3 reasons to call outside counsel for help?
Do you mean call outside counsel or pay outside counsel?
Let's do call.
Well, you should call them all the time, right? It's very lonely being the in-house antitrust lawyer, especially in smaller companies where there's only one. In fact, we went through some periods of time where we didn't have many, but you should really work, and you will if you haven't already. If you're in-house, you'll evolve relationships where you pick up the phone and talk to your in-house counsels, and they need to understand that you don't need a bunch of $1 hour charges at the end of the month that you have to explain to your general counsel why you didn't know a particular answer to a particular subject, right? But let's shift to actually hire outside counsel, right? Reason number one is basically that criminal law example, right? If there's some topic that you just aren't an expert on, right? I mean, I've done a lot of criminal related things, but I would probably not be entirely comfortable without, CSLAC by my side or another one of our, criminal lawyers, right? The other time is you just need more arms and legs, right? There's a third time, which I guess I'm going to throw in the pot. I don't know if you'd call this advice. I've been fortunate enough to work for 2 very strong general counsels, okay? But as outside counsel, I've been retained a number of times to be the bearer of bad news, okay? And basically the general counsel's afraid of the CEO, right? And so they want someone to come in and be the person that explains to the CEO that the deal's not going to go through, or yes, that was a per se violation. I raised this, well, for outside counsel because you're going to encounter it, right? Have fun. But really for in-house counsel, right? If you're encountering that, find another job. Okay, that's not a healthy environment, and you're go look for something else to do somewhere else. Anyway, that's probably enough on that topic.
Yeah, and I'll agree with all of those points. But getting back to not just hiring, but calling your outside counsel, you know, if you're the only one in-house who's doing antitrust work, and perhaps antitrust is only part of your job, and you got other responsibilities, you know, it's helpful every once in a while just to reach out to somebody who does antitrust full time and talk it through. Nobody can be an expert in everything, and I certainly strongly agree. If it's something criminal, you need to get some criminal antitrust expert, and yeah, John Cieslak and in our law firm is our go-to guy there. So yeah, if you can find somebody that you can bounce these ideas off of, that can be really helpful. And as outside counsel now, I mean, that's, I think, one of the services that we end up providing. Don't tell Jared Bona all the free legal advice that we're providing to our old in-house counsel friends. But, I think that we want to make sure that we are perhaps the sounding board. We can say, give a gut reaction of, that's something you need to pay a little more attention to, or no, that's something you can let go. And that can be very helpful. When I hired in at General Motors in the late 80s, I was one of 3 antitrust lawyers, and there were half a dozen other who had cycled through that job. And so, still remember that antitrust was not spelled with a hyphen. By the time I left, I was the only one for the entire globe, and it was only part of my responsibilities. It was nice to have the ABA antitrust law section, people there to chat with, because otherwise, it can be kind of a lonely job.
Yeah, hopefully Jared will not watch this webinar.
We'll set that
got a note from him to talk to Steve after this.
All right, Steve, we'll start with you on this one. What is the single most important thing to understand as an in-house antitrust lawyer?
I'm going to combine a couple of things, but the first one is one that Pat alluded to earlier. You do have to remember that your client is the company. Your client is not necessarily that person, that individual sitting across the table from you or on the other side of the email exchange. But putting that aside, you got to remember that as the antitrust lawyer, you are a cost center. You are a burden. You're not the revenue center. Unless you're helping license trademarks and patents, you're not generating an awful lot of revenue. What you're doing is helping other people do their job better. So if you love your job, presume that the client that you're talking with loves her job. Tell her what she needs to know in order to do it better, and then let her get back to that job. You're not getting paid to pontificate on all matters of policy issues. Maybe eventually, your business advice will be sought out because you've been around a long time. You've seen other parts of the organization that perhaps this individual is not. But what they're really coming to you for is legal advice. So you want to make sure that you're prepared to give your best advice at the right time, not too early, not too late. Make sure that you give it in a succinct manner. Make sure you give it in a form that is legible, is understandable. Get rid of the legalese. Stop quoting cases. Certainly stop quoting footnotes like some of my colleagues used to do way back when, and just help the client do her job better, because that's what your job is.
Pat, what about you?
Yeah, it's part of what Steve said, and it's the one thing I found myself saying to my attorneys in-house regularly, which is, if the client can't do what they need to do to succeed, none of us get paid. That to me is the most important thing to remember as in-house counsel. We
Okay.
converted that to protect and enable as a mantra.
I've heard you say that one before. I think it looks like we have time for a couple more questions. One we got in is, what antitrust issue is the one to watch in 2024? Pat, you want to go first there?
Yeah. I don't know that it's the issue so much as I mean, if you want to know what to watch, there's 50 articles a week in Law 360 that tell you what the issue of the day is, right? You know, what I watch is what the administration is likely to pursue. Okay, I mean that to me is the thing that's going to most guide clients, what they do, and the advice. And to me, you know, I mean, I'm seeing two things. I don't think any of these are any great insights, but they're clearly against mergers of any sort. And with regard to conduct violations, they're looking for cases that will be popular, that they think will be popular with large blocks of voters. Labor-related cases, cases where they attack large companies to claim that, you know, they're colluding somehow to raise their prices or to force lower prices. You know, and of course you got to keep your eye on the Phoenix Rising, which is the dreaded Robinson-Patman Act.
All right, Steve, is your answer also the Robinson-Patman Act?
Well, I was going to say that, but now that Pat's making fun of me about it, I'm not sure that I will. But I'll lump that into a larger description. That is, I think the agencies are more active, and yes, they don't like mergers, and so you need to understand that mergers are going to be more difficult to get through. But they're also looking for interesting, sexy ways of, you know, what we would in the old days call monopolization. But you know, it might not be Section 2. There might be some Section 1 issues, but ways for large companies, whether you think of them as, you know, large in the market share sense or just large, you know, absolutely, ways for large companies to abuse that power, quote unquote, and stop either the customers or even more likely the competitors, the smaller competitors, the new competitors, the potential competitors from jumping in and, you know, doing it, whatever it is that they want to do. In the old days, you might focus just on, well, is this good for the consumers? Now I think you need to make sure that, you know, is it good for the consumers, and what do the competitors say, and can an anti-competitive, at least allegedly anti-competitive story be told in the press? If so, that's something that I think the agencies are going to at least potentially look at. So if you had to point a gun to my head and ask for, you know, what part of the antitrust laws are hot, you know, you might call it Section 2 monopolization, but you know, it really goes even beyond that.
All right, let's do one more quick one, and then I think we have to wrap up. What is the what is the biggest difference between being in-house and being outside counsel? Pat, you want to go first there?
Yeah, you have to wait longer for your phone calls to be returned when you're outside counsel. Really? I think, and I'm sure this isn't a political answer, but maybe it's a good one to leave y'all with. When you're in-house, you really care if your clients follow your advice.
Well, okay, so it's up to me to be at least a little more politic. Again, I think I would say that, you know, in the in-house world, you see the issues, you know, all the time. You understand, you know, the speech that the CEO made, to all employees, and then somebody, comes and talks to you about, okay, here's how I'm going to implement it, but I need your legal advice on how to implement it. And so you understand the background more, and you understand sort of where your advice is leading the client, because you're sitting with them. Even if you're working from home now more often than not, you're actually with them. With outside counsel, it's more likely that somebody will come with and ask you a very discreet question, and you've got to pull back and try to understand the context. You don't have it as internalized as well as you did when you're in-house counsel. You get lots more questions like that, and you get to see lots of different industries and so on. But you're not part of the same team in the same way as you were when you were in-house counsel. So enjoy it while you can.
Yeah, that was a better way to say it, Steve. That's what I meant.
All right, guys. Thanks for indulging my questions.
Thank you, Molly.
Thanks, Molly.
Sure. I think we're out of time. I think Mondak will wrap us up.
Thank you very much, Molly, and I would like to thank all of our panel today, Stephen and Pat and Molly. A very engaging discussion. We really appreciate your time, your thoughts and your insights. It was a fascinating hour. It was great to spend that time with you today. So thank you very much also to our audience for being with us. If you did send in a question that we didn't quite have time for, I think Kristen has sent one in, we will send that on to the panel who will be in touch with you to get that answered. So once again, thank you to our panel, thank you to our audience. Hope you have a lovely rest of your day. Goodbye.
Thank you.